live. This is Law Call.
And welcome to Law Call. Sorry about that. I'm attorney Chris Young with the law firm of Perry & Young, and tonight we have a great show, taking phone calls from this weekend and also some email questions that we missed from last weekend. We're going to try to address those as well. But we're talking all about injuries, and tonight I've got my law partner and one of my closest friends in the whole wide world, Ted Howell, with us.
Yes,
and
sir.
Ted, we got some email questions to get to. We have some phone calls that we know are coming.
Yeah.
Some people
If
have
they
already.
if you want to fax it in, we'll handle it. Whatever you need, we'll take care of it.
Pony Express, baby.
Whatever.
There you go.
We'll get it
if you
done.
got a question, feel free to give us a call, 392-1544. You can always email us at lawcall@wmbb.com. Ted, let's jump right in tonight with our first email question. And here, if they'll put it up on the screen, there we go. Someone hit me and I kept going, or someone hit me and they kept going.
No, this is a different
Is this
one.
one?
Right
Okay.
here.
Well, here's another one. All right, drywall from Alan. I was on a drywall side job under no company or workers' comp. The ceiling collapsed on me and my friend. Had hospitalization and multiple areas of stitches. Who was responsible? The one who hired us or the property owner? All right, Ted.
Alan, that's a tough one right there, buddy. I'm sorry you're dealing with that. The way it goes in Florida law, with respect to what you're dealing with here, is what's called a premises liability situation. And it doesn't necessarily boil down to who was the owner of the property. It's more importantly characterized as who was in control and had the right to control the premises. So there's a lot of questions we still need to answer there to know who had that right to control that property. And then just because there was an accident and that the ceiling caved in on you does not mean that there's liability just because that. The fact that you were injured and something happened, we need to establish and prove that there was negligence, which means there had to be the failure to use reasonable care under the circumstances. So was this a situation where you're dealing with more or less a condemned building that should have been properly stabilized before you got in there and worked? Was it a safe working condition? Those kind of situations, if you're dealing with that, the liability is tending more likely towards the person who hired you, because that person should have taken care of that and made sure that was done before they allowed you to enter and do that work. And a lot of times when you're dealing with an owner-contractor situation, if the owner is truly hiring an independent contractor to do the work, a lot of times it's going to be difficult to hold them liable.
Right.
But however, if they overstep that boundary and are very diligent in activating and telling how you do the work and taking control and more or less acting like a general contractor or manager, they can pull themselves into liability. So it's important when you're in that role to make sure you keep that distance and let the people do their jobs.
Well, Ted, also, if an employer or a contractor does not carry workers' comp insurance, and they're supposed to and they refuse to, explain the difference in Florida law about that, because if you have workers' comp, you have immunity under that statute.
Yes, there's a quid pro quo in the workers' comp system where if you properly have the requirements and meet the statutes, then you are not allowed to be sued in tort. So you cannot get some things that we normally would get, such as pain and suffering and different mental anguish. A lot of the non-economic damages are not going to be allowed in the workers' comp system. It's basically you get your medical bills paid, and if you miss work, you get your time off on that as well. But if the employer is required to and fails to carry comp, then you can sue them in tort,
right? And
or you also have the option to pursue the statutory remedies on the comp. Typically, you're going to be better off to go after them under tort at that point in time. We've had several cases where that has been the case. And it's something that you got to explore and you got to look at. You always want to look at what are all the options so that you have the information so that you can make an educated decision on what you should do. And in a situation like this, there's going to be some issues first where you have liability, and then you got to find an avenue that actually gives you a practical recovery, because just because you have a claim, if you don't have a real remedy where you have an ability to collect, then it could end up being a Pyrrhic victory.
Right. Now, Ted, one of the biggest things about workers' comp, and that's going to lead into our next question, is if you've been injured on the job and you find yourself as an employee, make sure you file your claim. Make sure you notify your supervisor. Make sure you
quickly
whomever you got to go get to notify that there was an injury that occurred, an accident occurred, because that's paramount to establishing basically the foundation of an incident.
Absolutely, and you want to get it documented. If they kind of give you the runaround, make sure you want to talk to whoever's in the HR. Make sure you're getting that, and if you keep getting the runaround, make sure you ask to speak to the owner directly. do it, and if you keep, and you're not getting any response, make sure you put it in writing. You need to document this thing. But even if you do have a situation that falls under the purely normal comp situation, you're hurt on the job, we have it all the time, there still may be a tort recovery there.
Right.
Because, for example, if I'm a FedEx driver or someone and I'm driving and someone hits me, I was on the job, so I have a workers' comp claim, but the person that hit me is not off the hook. That is a third party that is not your employer, and if you can establish that they failed to use reasonable care and caused the accident, then you have a third party claim against that driver. So you need to explore it so that you know what your options are, so that you can make the best decision for yourself and your family.
Now let's switch gears on something else that you also need to make sure that you file a claim if you find yourself a victim of this, is slip and fall accidents. We have a lot of individuals that call our office every week and they've sustained an injury from a slip and fall. And one of the first things that you have to do after you make sure that you're okay is make sure that you file a claim with that premises, because if you don't, it's kind of like what we just talked about with the workers' comp issues. Establishing that you're actually injured there might be an uphill battle.
Right, and it's important, like I said, it's not just necessarily the owner of the property, it's who is in possession and control. So a lot of times you have landlord-tenant situations, and it can boil down to who had responsibility over certain areas and how that responsibility gets delved out. You don't need to get too worried and caught up on that. You call someone like us and make sure that you have that properly documented. But in situations, especially in situations where you're dealing with a slip and fall, and if you're dealing with possibly a foreign substance, whether it be water, grease, oil, you name it, it's important that you reach out to someone like us immediately, because we need to make sure that video evidence, witness testimony, whatever's out there is properly preserved, because if it's not preserved timely, it's going to be gone and you're never going to have the opportunity to get it, and it may make it an uphill battle, if not completely difficult to overcome, if you don't get that right at the start.
Now those two type of scenarios are very common in our area, because we have a lot of workers, people that work for large corporations or contractors, and we have a lot of businesses here too, in grocery stores. We're going to get to our next question on our email. Guys, if you have that up. If not, let's see here. Someone hit me and kept going. I had 3 passengers in my car who were injured. I have insurance. What are my options, Michael?
Well, Michael, there's a lot of things you got to explore here. First, someone hits you, you need to know, was that person working for someone? Because anytime you have an accident, you want to make sure you know, is it just a personal mission, or is it someone they're engaged in some sort of activity or joint venture for someone else? Because if they are, then not only are you looking at the driver of the vehicle, but you're also looking at that employer who he was doing the task for. In addition to the driver, you also want to look at the owner's insurance, because Florida follows what's called the dangerous instrumentality doctrine, which is a doctrine that we've established that says if you own the vehicle, you are essentially just as liable as the person that's driving the vehicle for any accident that takes place. So it's important that you know, when you let someone borrow your vehicle, you're opening yourself up potentially to exposure. So it's important that you carry adequate insurance. You can't say, I'm a safe driver, I'm going to be okay. You never know what's going to happen. It's important to make sure you have appropriate coverage to protect not only yourself, but anyone else that is driving your vehicle. So you always want to look at those 3 areas of recovery from the person that hit you. Are they working for anyone, the person that was driving the vehicle, and the owner of the vehicle? In addition to that, you have to look at your own policy, and there's several different areas of coverage that may come into play on that. If you live in Florida, I believe you do from that email, you're required to have no-fault PIP benefits. That's up to $10,000 that can pay for lost wages and medical expenses that you uncovered, and that triggers even if you were at fault for the accident. Clearly you weren't here, so it will apply, but even if you had been at fault, you would have those no-fault benefits. In addition to that, you might have what's called medical payments coverage, which is in addition to the no-fault benefits, which will further help you pay for your medical expenses. And then another area of coverage is the liability or underinsured motorist coverage that you may have on your policy, which stands in the shoes for anyone that hits you. If they have not enough or no insurance, it goes and triggers. So for example, if the person that hits you, if all of those struck out, then your underinsured motorist would kick in immediately and you'd be able to make a claim on that. Now, it's a liability claim. There has to be someone that was at fault.
So, but I'm sorry, but Ted, there's 3 scenarios right there that we just talked about. Workers' comp, we've talked about slip and fall real briefly, and now we're taking this question on multiple levels of insurance on a simple car accident
Right.
case. And what oftentimes may seem as a simple case can be very, very complex.
Yes.
And no matter how simple you think it is, there's always, it's almost like peeling off the layers
There's
of
always
onions.
layers, and and whenever you're in an accident, you start getting all of these writings in the mail.
Right.
And they're trying to get you to settle right away, and they start throwing out terminology and no fault, and you know, that's a question I get all the time. You know, we're a no fault state, so it doesn't matter. I'm like, no, that's
Right.
not what it means.
Right.
No fault means that everybody is required to protect themselves up to the first 10,000. That does not mean that someone that hits you is off the hook for an accident. So it's important that you reach out to somebody that levels the playing field for you, because the insurance companies have professionals working from them from the word go.
Yes.
They are already ready. They do this every day. Their goal is to try to get you on the phone as quickly as possible, get you to say things that will not be good for you in your claim, and then try to get you to settle it quickly before you even know the value of your claim. You know, Chris, we have people walk into the office every day, and they're like, and a lot of them want to ask, you know, well, what do you think my claim's worth? And I tell them very bluntly, I don't know. And anybody that tells you do at this point
at the
is
onset,
lying
yeah,
to
right.
you at that point, because you have not had the chance at that point in time early in the claim to get the necessary medical treatment, to know what the healing process is going to take, to know what it's going to take to get you back to where you were before this started. And until you have the time to go through that process, you can't fully comprehend the value of your claim. So it's important that you get the claim started immediately, but then step back, get the information so that you know what's available, and get the treatment that you need to do to get yourself back to being the old you as good as you can.
Right. So we're about to take our first break of the evening. Phone lines are open, 850-392-1544. You can always email us at lawcall@WMBB.com. When we come back, we're going to talk a little bit more about insurances and changes in the Florida law. And welcome back to Law Call. Before we get back into our segment here, Ted, we're going to talk about some insurance and the changes in Florida law. Mr. Bynum, I believe you called in during the break, and you're from Dothan. We want to let you know that I know that you want to go on the air. We'll handle your question tomorrow morning and get some more information from you. A lot of times, Ted, when we have medical malpractice issues or medical issues that are called in.
And so we'll
Mr.
take care
Bynum,
of
just
that
want to let
later.
you know we did get your, the producers gave us your information, and we'll give you a call in the morning. Now, Ted, we left the break moments ago talking about three large areas of the law and how basically complex they can be if you're not real careful with what you're getting into. But let's just kind of focus on car accidents because there's a lot of legislation that just changed in the state of Florida. We talked about that last week on the show, statute of limitations, how you calculate futures and past medical expenses. And basically, if you were partially involved in the accident, you could be found to receive nothing in the accident. But before we go there, it did not change uninsured motorists.
Did not.
And it didn't change PIP. And those are two large glaring issues in the state that everybody who is insured under a Florida policy needs to understand.
Right.
A lot of times people get involved in accidents and their insurance pays first. We're a no-fault state. They have a hard time with that because they did not cause the accident. And then you talked about it real briefly a while ago about uninsured motorists. So let's talk about PIP and what a no-fault statute really means.
I mean, we do have a no-fault system in the state of Florida, but that does not mean that we do not have liability claims. What it does require is that we all have $10,000 of insurance that is the first layer of protection anytime you're in an accident. So when you go, for example, if you've been in an accident and you go to the emergency room, even if you have health insurance, whether it be private health insurance, Medicare, Medicaid, if it's an auto accident, they're going to ask you what was your automobile insurance. And some people think that that's crazy that they're asking them that. And the reason is, under the Florida statutory system, is that that's your primary health insurance when you've been in an accident. So the first thing that gets billed is that PIP no-fault benefits. And until that exhausts, it is your primary layer of insurance. Right. So everywhere you will go until you exceed the $10,000 in coverage will be paid for by that PIP no-fault benefits. And if it does not get exhausted through the medical expenses, you can also use it to supplement your wage loss up to 60%. But a lot of times, unfortunately, if you have a bad accident and have to go to the hospital, especially here in Bay County with the way our hospitals charge, you will lose most of your PIP in that first round of treatment.
Because there's only $10,000.
There's only $10,000. That has not moved in
here's
years.
Something very important. It hasn't moved since, I believe, the early 70s, I believe it is.
And expenses have changed a little bit since the 70s, if you don't know that.
Just a little bit. And so if you do not report that injury within 14 days, and I say report it, you have to actually go be diagnosed with an emergency medical condition, an EMC. You can lose 75% of those benefits, and those benefits are cut from $10,000 down to $2,500.
Yes, it's extremely important to go within the first 2 weeks.
Now that's basically a broad overview of our PIP. But the more important thing is because we have PIP, we don't have what's called mandatory bodily injury coverage, which means someone can actually be legally insured in the state of Florida and not have any insurance to pay you for the damages they cause. Now, that's why it's very important to carry what's called uninsured or underinsured motorist coverage. And Ted, that's probably the most important policy or provision coverage area on your policy, but it does not mean that you have full coverage.
No, I mean...
Or full coverage doesn't mean you have that.
It does not mean it. And technical definition of full coverage in Florida means, and I hate that terminology, and people use it all the time because in theory
that's what they're told.
Unlimited insurance, but full coverage, the definition is legal coverage under Florida, which only requires you to have the PIP no-fault benefits and $10,000 of property damage liability. So if you damage someone's other vehicle, you're required to carry insurance to protect that, but the law in Florida does not require you to take any protections to protect them from their actual injuries. And in fact, Governor DeSantis had a bill the last year, not this past year, but the year before, that would have put us in line with most of the rest of the country and required mandatory bodily injury coverage of a minimum of $25,000 per person, $50,000 per accident throughout the state of Florida, which I think would have been a very, very good step forward for protecting everyone.
But we're not there yet.
I think there's a chance that still may come back.
We're pushing that through, and but that's why you have to carry uninsured motorists. Though.
Yes, and uninsured motorists for that reason is extremely important, especially in the state of Florida where people are not required to carry liability insurance. So you need to purchase something to protect you if someone hits you that has little or no insurance. It is so important that in order to not have it, you have to actually sign a form saying, I've been made aware that it's offered and I am not going to take it. And if you don't take it, what you're doing is running the risk that you will be in an accident with one of these people. And the whole reason we buy insurance in the first place is to protect us from things that are risky, the things that we cannot afford to lose. I often say I would never insure this pen. If I lose this pen, I'll go buy another pen.
No, you'll go to the supply cabinet and grab
another one. Yeah. But if my house burns down, I would like to have insurance to cover me for that. Well, in the same sense, the riskiest thing most of us do in any given day is drive to and from work, around running errands, getting our kids, whatever it may be, because we can't control that environment.
Right.
You can drive as safely as you want. You can be the most cautious person, but someone can hit you and cause us.
But not only
severe
can we
injury.
not control that, we can't control somebody else's responsibility to carry proper insurance or carry enough insurance. And so, you know, you mentioned it earlier, Ted. The $10,000 cap on PIP is basically that represents pennies on a dollar of what claims or medical bills actually get charged and claims are worth. But we haven't adjusted that, but we're working on with the state legislature to try to get some changes passed through. But until that happens, that's why uninsured motorists is so important to have on your policy, and to make sure that if you don't know that you have it, you can always call our law firm.
Yeah.
We get calls all throughout the week, and we're glad to put you through to an attorney that can review the policy for you. And we do that for free because we want to make sure that you're properly covered. And if you don't feel comfortable calling our office, call your insurance agent that sold you the policy, and they're more than competent enough to sit down with you and explain to you the coverages that you do need. But if you do have an agent out there that tells you that you do not need uninsured motorist coverage or underinsured motorist coverage, you probably need to change agents and call our law firm, and we'll tell you what coverages that you actually need to have. Because when you look at the cost of that provision on your policy is extremely cheap considering what you pay for your liability insurance and your property damage insurance. And to have that extra little bit of coverage goes a long way, because not only does it cover you, if you have a spouse or children, it covers them as well, even if they're not in their vehicle.
And it can even go more broadly than that. I've had situations where nieces, nephews, I mean, as long the typical language of a UM policy is if it's a resident relative.
Right.
So by blood or marriage, if you are a resident relative, and that means you live in the household with the policyholder, then there's a potential avenue for recovery on that. So we always have to look at that. We have to ask, what family members do you live with? Does your spouse have a different policy than you? And we have to look at that. And it's a very important, it's been key in several situations to getting people properly compensated.
Now, the other caveat of that is if they cannot provide that rejection form that they say that you did not, that you signed, but they can't provide that to us, and even though you did not pay for the premiums, you are still entitled to that insurance. So that's why it's extremely important to retain a law firm that knows and specializes in this day in and day out to handle that.
And not only do you have that coverage, you have it stacked for, so if you have however many vehicles you have it that many times multiplied times the amount of liability coverage you carry on your policy.
So I'm selling insurance here, I feel like, Ted, but make sure that you actually get stacked, not unstacked, because once you get the coverage, they will ask you, do you want stacked or unstacked, and you always get stacked coverage. So, Ted, we mentioned a while ago, you know, you have to report your accident or go get medical treatment within 14 days. When we come back from our second break of the evening, let's talk about real quickly about the statute of limitations and why that's important if you've been involved in a car accident or any type of negligence case. Phone lines are still open, 850-392-1544. You can always email us like others have tonight at lawcall@wmbb.com. Taking our second break of the evening, and we'll be back shortly. And welcome back to Law Call. We're in our final segment, Ted. We only have about 3 or 4 minutes left in the show. Mr. Gorbett, you also called in about a timeshare question. We will have someone address that with you first thing tomorrow morning. So be on the lookout for our call. And thank you for watching the show and calling in. Ted, to get back to the topic of the evening, though, we kind of left the last break talking about why it's important for people to understand the statute of limitations. Yes. Now, we went from a 4-year to a 2-year, and why is that important?
That's historically we've had 4 years, which means 4 years for a negligent claim to either resolve it or have your lawsuit filed. And with these new amendments in the tort reform, it's now been reduced to 2. And many times, in 2 years, I have a number of cases where folks are not finished treating. They do not know the full magnitude of their loss at that point in time. So that means we either have to settle it without full information or we have to go ahead and file that lawsuit before 2 years. So please make sure, especially, I know a lot of people get out there and Google things, and there's a lot of bad websites out there that may not have been updated. So it's important that if you've had an accident, because these things are always changing, and Florida is a state that has a lot of statutes.
Well, the main thing changes. The main thing to do is if you've been involved in an accident, you find yourself being the victim of something, seek out an attorney immediately, quickly, do not delay. Now, Ted, getting to our shout-outs, we have a slew of shout-outs, but we have 3 pictures that we want to get to first.
Let's get them on.
I believe the first picture is my little puppy dog, Boss Man, there, watching us last weekend. And my wife told me that he was getting ready to watch us this week, but I think he's probably...
Oh, look at there.
And then we have Nick Utz's little baby, Hudson, and future, present law call caller, observer here, I guess, yes. And then we have Harriet's, she works with us in our downtown office. King is watching.
She keeps us all straight.
Larry and I last week as well. So, anyways, we've got shout-outs, Ted.
Yep,
so,
I got my, I'll go ahead. I got
run down, brother.
I got my cousin Brooke watching tonight. We got Buford Jewell up in Jackson County watching. We have my son Judson. Their junior Bucks team won in overtime. Big win. He wanted to make sure he's trying to stay up. And then I got Trina Birch became a grandmother this weekend.
Congratulations, Trina.
And Doug Moore's watching tonight. Loves your jacket.
Well, I'm glad that BJ's watching because BJ thought it was red, but my wife promises me that it's pink and it's Breast Cancer Awareness Week.
BJ, I'm right here. I can't tell the difference.
Well, BJ, you and I are both colorblind, buddy. Anyways, I want to give a shout out to my wife, Ashley. She's supposed to be watching maybe, but I got a feeling that her and Boss Man are probably snoozing. My mom, Trace Smith, Judy Smith, Gary Starr, Pam Myers, Brian at Publix, and our friends down at the Grand Marlin. And Miss Cheryl Stubbs, who actually texted us and said that Ted is the best. So
we love you too, Cheryl.
Miss Cheryl, I'm not sure what he knows on you, sugar, but thank you for the nice compliment. Join us next week, same time, same place, and we appreciate you watching, and have a great week.